Reading the second part of your message, my heart sank. And I'm really sorry. For sure fell short. And you worked really hard on that. And the way you framed it and how that made you feel, I just want to say thank you for sharing that with me. That takes a lot of trust and vulnerability. I feel really grateful that you feel safe enough to tell me that that's how you feel.
Well, it would appear that Blake Lively cracked under pressure. And in her deposition, she exposed some details about this quote unquote smear campaign that she has been telling the whole world has been going on for months and months and months. And this is the reason why her reputation is in the toilet. And this is why everyone hates her. It's not because of her own doing, but it's because of Wayfair. And apparently, Blake Lively is abandoning the whole premise that brought her to today. The whole New York Times article of they smeared me before and during the premiere, they retaliated against me. Well, after her attorneys apparently filed this letter to the judge to clarify why they want Brian Friedman's communications with content creators or with literally anyone and why they want Mr. Friedman's bank accounts and telephone records, they had to let the court know that, the reason why we're doing this is because Mr. Friedman is running an ongoing smear campaign, and Mr. Friedman, he's doing these interviews and he's calling her derogatory names and this and that. And it's very important that we have these details because we have to, show you that this is what he's doing, turning him into a fact witness instead of a attorney, which a lot of the attorneys on social media are saying is pretty underhanded and dirty. It's not generally something you would do to your opposing counsel because then they can do it to you. You generally don't try to drag in the opposing counsel into your case and attack them. It's just not good. It's not good practice. It's not showing that you respect the process or the court. It's having to destroy them in order to win. And if that's all she's got right now is to destroy Friedman, she doesn't have anything. So it's like a deflective tool. It's a power move. It's underhanded, in my opinion. But Kevin responded, which exposed some details about her deposition. And I really like that Kevin Fritz is now starting to use more pointed language and he's being more aggressive in how he's phrasing things because I think we're really trying to drive home to the judge that what she's doing is harassing people through subpoenas. They write, to justify the harassing subpoena, the letter erroneously alleges that Brian Friedman Esquire defamed Lively and that his conduct has amounted to public relations work rather than that of an attorney. It appears that Lively is slowly realizing that there is no retaliatory smear campaign by the Wayfair parties against her. Consequently, Lively is shifting her focus to Liner Friedman in connection with her 14th cause of action, which alleges that certain Wayfair parties, through their attorney Friedman, purportedly defamed her via post-litigation statements to the media. So he's claiming that she doesn't have a lot of evidence for a smear campaign. So instead, she wants to move to defamation by them, shifting where she's going to, try to get the most bang for her buck. And they go into something which is redacted so you can't see it, but it says, upon questioning by Friedman at her recent deposition, Lively admitted that the only ongoing smear campaign about which she has personal knowledge involves, and then it's redacted, and it apparently occurred at 2 hours in to this. And then, so we don't know exactly what they said there, but we can imply that it has to do with counterclaims because he says counterclaims filed without retaliatory motive with a reasonable basis in fact and law, such as claims filed by the Wayfair parties against Lively, do not constitute an adverse employment action within the meaning of anti-discrimination statutes. Moreover, statements by the Wayfair parties to the media directly or through their counsel defending themselves against her bogus claims of harassment do not qualify as retaliatory conduct. So she has no retaliation outside of apparently the fact that they filed a countersuit against her and that defending themselves in the media is thus proving that they're retaliating against her. Mind you, they would have never said a word had she not brought her own bogus lawsuit to the forefront that they would have to have defended. Thus, she's seemingly abandoning this whole, well, they smeared me with an untraceable digital army, and now it's, well, now they're retaliating because they're defending themselves and they filed a retaliatory lawsuit against me. And they're claiming that this actually doesn't constitute an adverse employment action. And they use rulings by Judge Lyman as proof for that one. And then also statements by the Wayfair parties to the media or directly or through counsel defending themselves against Lively's bogus claim of harassment do not qualify as retaliatory conduct. Again, using one of Lyman's own rulings from his lawsuit that he went over with McSweeney versus Cohen. He goes on to note that as for the 14th cause of action for defamation, New York law provides an absolute privilege for communications made by individuals participating in a public function, such as executive, legislation, judicial, or quasi-judicial proceedings. The privilege is accorded statements made at all stages of a judicial proceeding and communications among the parties, witnesses, counsel, and the court, provided that the statements may be considered in some way pertinent to the issues in the proceedings. The privilege applies to all statements made in or out of court, regardless of the motives for which they are made. In short, Lively is aggressively pursuing discovery for a defamation claim that will surely be dismissed upon a dispositive motion. So what they're saying is that the same way that Lively got litigation privilege for what she said about them in the CRD complaint and in the lawsuit here and the statements that they're making to the press here, and that was fundamentally why the case was dismissed, they're saying the same would apply to them. So if she is going to use defamation about statements made within litigation or even outside of it, as long as it pertains to the litigation at hand, it's protected and shielded from any lawsuits. So what they can do are one of two things. They can file a motion to dismiss to her most recent second amended complaint, or they can do a summary judgment and have it dismissed that way. So they have two ways to get rid of that claim of defamation: a motion to dismiss or a motion for a summary judgment, because they're saying we have litigation privilege to do our job the same way she does. In any event, Lively does not adequately address the court's inquiry concerning the undue burden imposed upon Liner Friedman by the subpoena. According to Lively, the subpoena is not unduly burdensome because on December 23rd, 2024, days after she caused her allegations in California civil rights complaint to be widely disseminated by the New York Times, her counsel demanded that Liner Friedman cease and desist from, in essence, publicly responding on behalf of the Wayfair parties. Therefore, according to Lively, Liner Friedman has known for more than 6 months that she may seek discovery from the law firm. However, at the hearing on the motion, the court astutely asked Lively's counsel why discovery was needed from Liner Friedman via the subpoena in connection with the defamation claim if Lively knows which statements are at issue. Lively had no viable response at the hearing and does not offer one now. Indeed, the second amended complaint not only identifies the specific statements by Friedman that Lively contends were defamatory, but also conveniently provides a link to the publications. In brief, Lively knows to whom the statements at issues were made, where they were published, and when, which renders the subpoena unnecessary and unduly burdensome. Oh my goodness. So they're basically just asking the court to dismiss and quash this subpoena, and she doesn't have anything that's hidden here. Essentially, they were hoping to create a claim, in my opinion, by sending that cease and desist and telling them to stop their retaliation, right? So Lively thought that she could file this CRD and then tell them that they didn't have a right to defend themselves, thus controlling their speech, right? Controlling the speech of Justin, Jamie, and any of the Wayfair parties, making it so that if they even try to talk to the media or a content creator or an independent journalist, they are retaliating against her. Think of it this way. Any good lawyer, when you decide to file a lawsuit, will counsel you and tell